Today, our contents consists 5 parts, and the first 3 parts, I think I will mention 3 scenarios. And on the first session, I will give you a small introduction and explain some typical scenario you may face. And the third and the second part, I think I will share some scenarios maybe you will ignore. And the fourth is about the legal landscape and the strategy you could use for your future business operation. And the final one is our conclusion. Let's start. Yeah. What does made in China really mean to you? I think our common sense is like just an label, or is relevant only for export or customs, or is only a cost-saving production step. You may say that no local sales means no risks, but what is the reality? The reality is that it's about legal jurisdiction. Your products are subjected to Chinese law the moment they are built. It's also about the supply chain explosion. Your most designs and semi-final goods are physically in China now. You are under Chinese supply chain. And you may also ignore that. It's under Chinese IP creation zone, where your prototypes can become someone else's patents. So the reality is, manufacturing in China without IP registration is like building a house on land you don't own. What is the typical manufacturing? The typical manufacturing is under OEM circumstance. Someone may register your IP, and in China, and China is also your big market, you will face some infringement cases. But is it all? Absolutely no. Let's move to other scenarios. From the first one is when made means manufacturing. Under this circumstance, EU brands outsourcing production to China, pure of goods exported to EU, global markets, Latin American, or Mexico, this kind of thing, and zero sales in China. There is a danger myth. Since we don't sell in China, we don't need a Chinese trademark. But under this circumstance, the manufacturer may register your brand name first and unauthorized third shift production sold to other markets. It's very common because now it's a global economy, and it's the digital economy, and it's easy to sell to all the other markets in the world. And being held hostage at customs or forced to pay licensing fee, not real licensing fee, to your own suppliers. Let's say a real story. No sales in China, but IP gets stolen. The background is that EU outdoor geo SME with established global sales and 100% production in Zhejiang province, and all goods exported to EU. No Chinese trademark registered, only relying on English purchase orders. After 5 years, because of the markets expanded, the factory's affiliate registered the brand's trademark in China. So, what action they take? Factories recorded their trademark with China customs, and the customs blocked the brand's exports, and the brand filed a trade invalidity. The lawsuit came in by face registration, and may also sell alternative suppliers. They require required creating new modes from scratch. What's the outcome? Finally, they won the lawsuit after 18 months. The mark was cancelled, but the supply chain halted for 6 months. They missed the critical Christmas peak season. They suffered a significant loss of sales and was forced to pay a settlement fee just to retell the original moves. What we can learn from it? The first one is that defensive registration is mandatory. Register trademark in China even if you don't sell locally to prevent scratch. And the second one is that contract doesn't mean registration. English contracts cannot override Chinese first-to-file system. And the last one we could learn is that customs control is crucial. If you don't record your IP, someone else can use their rights to stop your goods at the border. So it's very important. How can you secure your manufacturing base? The first one, register early. File trademarks in core classes before mass production begins. And second is about the contract. Contract clause is very important, except please state that moves, tooling, and drawing belong to the brand owner. And the last one is that customers record. Proactively record your trademark with Chinese customs to block counterfeit exports. Now, let's move to another tab. The other scenario is about the test. When the made in China made means in test or prototype. Nowadays, Chinese spirit make China has become the largest supplier for all global markets, and many EU SMEs want to use Chinese companies to have a test or have a sample, but they think it's just a prototype. We don't have a launch, so no need for patents. But there are also some hidden risks. Your design may be saved. CAD files linked before market launch, or you may also fall into first to file trap. Suppliers file a design patent before you do, and you may also have some problems about the ownership. You perhaps have ambiguous ownership, unclear rights over joint improvements. Now let's move to another real case about the stolen innovation. The background is that an Italian smart home startup sent CAD files to Shenzhen prototyping studio. Only email confidentiality agreement. They didn't sign any NN or NDA agreement, this kind of thing, and no patent filed before sharing this design. So what actions did it take? They tried to complain to the e-commerce platform, but they rejected. Because no Chinese patent certificate, and they attempt to trade secret lawsuit, but they don't have very, very strong evidence, and they don't have very formal contract. They have to negotiate, but they require them to buy back their own patent from the studio. It's kind of ridiculous. So the outcome of this case, the first one is that the product launch delayed by more than 3 months and they missed the market window. The second is that the cheap copies flowed in Asia, especially in Chinese market, and they undermine the pricing strategy. And the final It's absolutely they have some financial loss, including buyback, legal fees, and delayed costs. So what could be learned from this case? The first one is file before sharing. Please submit a patent application before signing any CADs or other materials to China. And the second one is using Chinese language agreement, because English NDAs are often unenforceable in China, and they must be localized with high penalties. And the last one is signet production. Don't give one supplier the full design. It's not because you don't trust them. It's protect yourself, to protect your code secrets. So how could you secure your innovation pipeline? The first one is priority filing. Filing in your home country first and claim priority in China, or file directly in China immediately. And second one, you could also use the contract tool. Localize your contracts, sign English language agreement, or at least English-Chinese language. English NDAs are often unenforceable in Chinese courts. And the final one is to control the flow. Limit access to core technical secrets. Keep critical assembly in-house or in trusted jurisdictions. So here's the cases I share. And now let's move to the other session. It's about the legal landscape and the strategy. But before that, we have a small analysis and give you some key points. The first one is that risk comes from manufacturing and excise, not just sales. It doesn't mean no sales, no risk. And the second one is that infringing goods can be sold globally via cross-border e-commerce platforms like Amazon, Temu, Alibaba without entering the Chinese domestic retail market. So the conclusion that if your supply chain is in China, or maybe have some relevant with China or Chinese, your IP battlefield is in China. And now I will share something about the current legal trends and give you some updated policies from e-commerce platform. Let's start with the trademark. Currently, Chinese government wants to amend our trademark law, and there are some things you could emphasize. We will take more attention on bad faith registrations and increase punitive damages for increasement. So our business environment is improving, but you still need to register an IP right to benefit. The other thing is about the e-commerce platform. These platforms now strictly require Chinese IP certificates for takedown requests. Without a Chinese trademark or patents, you will have no leverage to remove fake listings. So now move to the next session. The IP safeguard strategy I could give you. It will consist 3 phases. The first one is prevention. Under this phase, you need to register your key IP, like trademark or design, and it's very good for you to sign strong contract, Chinese NNA and IP ownership clauses, and after that, you need to moderating. The base for you is to watch the trademark the trademark entities for similar filings or scan e-commerce platforms for unauthorized listings. And last of this, when you face some circumstance for infringement or requires some licensing fees, this kind of things. First, you need to comply to the platform and fast taken down this, and you need to submit your Chinese IP certificate. And the other way you could use is to apply for administrative enforcement. You could complain to the Market Supervision Bureau in China. And the last one is our customs. Seizing infringing goods at the border is also a great way for you to give this kind of response. Now, it's our final session, and there's something you could take away, and it's our summary. The first one is to redefining risks. Made in China doesn't mean the typical scenario made in China. You should even if you don't care about the Chinese market, but if you manufacture in Chinese market or prototyping in Chinese market, it's a high risk zone. And second one, registration first. Registration means you will have the ownership. Do not solely rely on the contracts. And the third one is speed matters. File patents before sharing any design files. And the next one is localize. Use Chinese language contracts and adapt it to local laws. It's very efficient. And the next one is that cost benefits. Provision cost is much lower than remediation cost. And the final one, if you face this kind of circumstance, and if you have any questions about IP matters in Chinese market, please contact us. Thanks for your attention.